All right. Good afternoon, everyone, at least those of you on the East Coast. Welcome to Small Government Contractors and the FCA. Is more enforcement on the horizon? And before we get into the webinar today, I'm going to give you the short answer. Yes, Jackie and I are going to talk a little bit more about that in detail today, but when in doubt, the answer is going to be in favor of more enforcement by the government. But without further ado, my name is Matt Feinberg. I'm a partner at PilieroMazza in our litigation and dispute resolution practice group. And I'm here today with my partner, Jackie Unger, who will introduce herself in a few minutes. We are the co-chairs of PilieroMazza's False Claims Act and Audits and Investigations practice team. So we try to focus a significant portion of our practice on keeping up to date with what's going on in the FCA world. And we hope to share some of what we know with you today. If you have any questions during the webinar, feel free to use the questions tab and send them to us. We'll try to answer everything we can. And if we can't, we'll follow up with you afterwards on a more individualized basis. So why don't I introduce Jackie Unger and then I'll give you a few disclaimers. Jackie, how you doing?
Hey, Matt, doing well. Thanks, and good afternoon, everyone. I'm glad to be joining Matt and be here with all of you today for this webinar. As Matt mentioned, I'm a partner in our government contracts group. We help both large and small contractors navigate all aspects of doing business with the government. And in addition to helping clients who face government investigations, I also counsel clients on the FAR and SBA regulatory compliance issues, represent clients in bid and size protests, as well as government and teaming partner disputes. So that's a little bit about me.
Jackie also probably left this part out on purpose, but sometimes I drag her into FCA litigation, which she appreciates greatly. So Jackie and I have a lot of experience working together, particularly on these small business FCA issues. So like I said earlier, let those questions fly and we'll do our best. But before we get started on the content, lawyers have to give disclaimers, right? So here's our disclaimer. Our webinar today is provided for informational purposes only. It's not intended as legal advice for your specific situation. It's also not intended to create an attorney-client relationship between you, the listener, and us, the presenters. Your specific circumstances may differ from the cases we talk about or the issues we talk about in material ways. So if you have specific questions about an event or a circumstance that you are experiencing or your company is experiencing, we would encourage you to reach out to us directly so that we can understand the specific facts. We don't want you to rely on generalities because FCA cases are very specific, they're very fact intensive, and the presence of a fact or the absence of a fact may materially alter our legal advice with regard to a specific situation. So without further ado, we will move on and get started with our presentation.
Great, thanks, Matt. So first, before we dive into the substance, we want to give a little overview of what we're intending to talk about today. We're going to start today by giving a brief review of what the False Claims Act is for those of you who may not be familiar with it or maybe need a refresher. We'll also talk about the types of conduct that can create an FCA violation. And we'll talk about recent enforcement trends that we've been seeing, particularly in the healthcare industry, with COVID-related fraud and with government procurement fraud. Then we'll provide an update on a few other important issues that have cropped up over this year, as well as some of our expectations for the next year. And we'll wrap up by providing some guidance and best practices for protecting your company from potential FCA liability. So with that, let's dive into our first topic. What is the False Claims Act? The FCA was created in 1863 in response to defense contractor fraud during the Civil War, when some unscrupulous contractors sold the U.S. Army horses in bad health and faulty guns and ammunition. So that's the background that we're talking about. But since then, it's been significantly expanded, and it's used as the primary vehicle for the government to collect money obtained by contractors through misrepresentation or to retrieve money that's improperly withheld from the government. So for a brief primer, there are a number of elements that must be met to establish liability under the False Claims Act. First, there needs to be a submission of a claim, which is a request for money or property, like an invoice or an obligation to pay the government. When we're talking about a claim being false, that means the claim of entitlement to the funds was improper, incorrect, unlawful, or unjustified, or supported by a misrepresentation of fact. But it's important to recognize that not all incorrect or improper claims rise to the level of a violation of the False Claims Act. There are a few other elements that must be met for there to be liability. The false claim must be submitted with knowledge of its falsity. Knowledge means actual knowledge, reckless disregard for the truth or falsity of the claim, or deliberate indifference as to the truth or falsity of the claim. So it's critical to understand that liability can exist not only where there's blatant and intentional fraud, but also based on reckless behavior, which is something that has been interpreted as akin to gross negligence. Or there can also be liability for deliberate indifference, which is the sort of situation where you stick your head in the sand like an ostrich, where you're purposely ignoring the potential wrongdoing around you, particularly if there's some basis for you to be aware of that wrongdoing, if some complaint has been made and you're avoiding figuring out whether that conduct is actually improper. Finally, for a submission of a false claim to result in liability, the false statement must be material to the government's decision to pay, meaning that it has a natural tendency to influence the decision maker. So we also want to distinguish between civil and criminal false claims. Most of the time we see allegations of civil False Claims Act violations, which will result in the government seeking repayment of damages and penalties. But for more egregious FCA violations, which usually involve intentional fraudulent conduct, the government may pursue the misconduct criminally against the company as well as the individuals involved. So moving on to types of FCA matters. There are two primary types: government-initiated matters and qui tam matters. Government-initiated matters typically arise out of an audit or investigation, or a complaint to a government whistleblower hotline, or an office of the Inspector General or the DOJ. In these cases, the company or the individual being investigated usually will receive a subpoena or a civil investigative demand from a government agency. And then if the investigation proceeds to litigation, the United States will be the plaintiff and will pursue the FCA violation and damages against an individual or the company. But the FCA also establishes a private right for individuals to file what is called a qui tam matter. So in this type of case, the case is brought on behalf of the United States by a whistleblower who's called the relator, who could be, it could take many different forms. It could be a former employee or a competitor or some other individual with inside knowledge of the company, the potential defendant's actions. So in this situation, for a qui tam matter, the whistleblower files the qui tam suit under seal, so the defendant doesn't know about the lawsuit right away, and the government has a chance to investigate the allegations and determine whether to intervene and basically take over the case from the whistleblower. And eventually the case will become unsealed and then litigation could commence, but that could occur several years down the road. So those investigations can last for quite a while. Once the seal is lifted, if litigation proceeds, then it plays out pretty much the same way as the government-initiated matter. One other aspect of the qui tam matter to point out is that qui tam relators are generally entitled to between 15 and 30% of the total damages recovered by the federal government. So they're highly motivated to come forward with allegations because of that incentive for the monetary recovery. So there are several common types of FCA violations. So I want to walk through these different types of violations and give some examples of what constitutes each type. The first is the presentment of a false claim for payment. So this is kind of the straightforward situation where the contractor submits a false invoice requesting money when it's not entitled to that money. So this could occur when the contractor bills for services that weren't provided, or if they bill at the wrong rate. So in that sort of situation, on its face, the invoice is incorrect because it's reflecting services that weren't provided or the wrong rates. The second type is where the contractor uses a false record or false statement in conjunction with a request for payment or to induce the government to pay a claim. This often occurs where there's some certification that's required. So this could be an express certification that influences payment, like a false certification that all contract requirements are met, or for instance, that all subcontractors have been fully paid, or that the amounts in the invoice are for work actually performed when that's not actually the case. It would really depend on the language of the contract and the invoice as to what representations are actually required under that contract and which ones are being made. So you need to pay attention to the language that you're making, the certifications that you're making in your request for payment. But there can also be liability for implied rather than express certifications. This occurs where the certification is not expressly required by the contractor in invoice, but by its very nature, there's an obligation that the contractor would have to meet. That could be, for instance, that the contractor is in compliance with applicable laws and regulations, or compliance, that the contractor is in compliance with cybersecurity requirements. And by submitting your invoice, you are representing that you are in compliance with these requirements. But there's a duty to not knowingly withhold information that's material to the government's decision to pay. So a contractor's silence about its non-compliance with those material requirements can lead to liability. Even though there's no express certification of compliance, it's implicit in the request for payment that you are compliant with those requirements. FCA liability can also be based on the theory of fraudulent inducement, which is where the contractor induces the government to award a contract through false statements or fraudulent conduct. For instance, fraudulent inducement could exist where the company misrepresents its small business status, or where it makes material misrepresentations in its proposal about how it will perform. And when that occurs, all claims for payment submitted to the government under that contract are considered false, rather than, one invoice potentially having the wrong rates billed in it, where there's liability for that single invoice. Where there's fraudulent inducement of a contract, every single claim for payment will be considered false and could lead to an enormous amount of liability for contractors. A third type of violation is a reverse false claim. So in this situation, the contractor is already in possession of money or property that the government is entitled to, but it fails to return that money or property. So an example of this could be where the contractor is aware that the government overpaid, but it fails to return that overpayment despite its knowledge of it. And we also see this with respect to the PPP program, where someone receives forgiveness for a PPP loan that they weren't entitled to. And then finally, we've got liability for conspiracy under the FCA. So this could occur where a subcontractor is submitting false invoices to the prime contractor, who submits the invoice to the government, or there may be a conspiracy between owners of two companies who are teaming together to falsely represent one company as a small business, then have it pass through the majority of the work and revenues to the other company, who's not a small business, to perform. Many different types of conspiracy. Those are just a couple examples, but generally conspiracy requires an agreement between two or more parties to commit an unlawful act by unlawful means, and at least one party commits an overt act in furtherance of the conspiracy. So those are the main types of FCA violation we see.
Yeah, so we're going to talk a little bit about some examples, some sort of everyday or recent examples of actual cases that have come out in the last year or so, a few slides from now. But something Jackie said brought something to mind that I think is particularly relevant to small businesses. When you are a small business, you might have a set aside designation. Maybe you're an STV, OSB, or a woman-owned small business. But you also are designating yourself as small for the NAICS code that's relevant to a given procurement, in most cases, unless it's full and open. When we talk about implied certifications or fraudulent inducement, it may be an implied certification that you are actually small at the time of your bid, or when your status was relevant for a particular bid on a task order. Things that can impact that are things like affiliation. Are you affiliated with another company? And a lot of small businesses aren't paying as close attention to issues like affiliation. They may be fully compliant with their obligations with their own net receivables to be a small business, but they're not really thinking about businesses they may be affiliated with. And so when we talk about making sure, and this will happen a little later in the webinar, making sure you're in compliance with the requirements, you need to have a pretty good understanding of the regulations that apply to you, not just on size and status, but on things that affect your size and status. Because at the end of the day, there have been a number of instances over the last several years where False Claims Act liability, or I should say False Claims Act investigations and lawsuits have occurred because small businesses working together were deemed to be affiliated and no longer eligible for a contract. So that's just one thing. Jackie's can talk about that offline if necessary, if you have questions about affiliation or your small business status, but that's just something else to keep in your mind when you're bidding on contracts. Is it possible that I'm not small because of my relationships with other contractors? So the FCA is a pretty forceful statute, I'll say. There are a number of penalties and multipliers that factor into potential FCA liability. There is a mandatory damages component. And what I mean by that is that the False Claims Act itself imposes liability simply for the making of the false statement or submitting of the false claim. So like Jackie mentioned earlier, if you were to say submit an invoice with unallowable costs, or you billed at the wrong rate or submitted an invoice for work that wasn't done, if that's a one-off situation, then that violation of the FCA comes with an additional penalty of somewhere between $12,500 and $25,076 per violation. If you're on a contract that invoices by, say, a blanket purchase order where you're invoicing by the order, you could be submitting hundreds or thousands of invoices to the government per month. If those are all marked up, say you have a fee attached, there's an agreement to a fee of 2.5%, but your math calculates out to 3% and you know about it, every single invoice could potentially be penalized at that same $12,500 to $25,000 rate. So those mandatory penalties can add up very, very quickly. In addition, the False Claims Act imposes treble damages on a company that is found liable or a person found liable under the FCA. So what that means is that even if the government was defrauded only by $100,000, the government can recover, in addition to the penalties, 3 times the amount of the underlying fraudulent amount. And that amount is determined based on the type of claim pursued. And so we have some examples there on the slide for you. In the example I gave a little bit earlier, your invoice includes an unallowable cost of $150,000. Your treble damages are going to be 3 times that $150,000 plus the penalty for that one. The liability would be the penalty for that one violation. But in the example I gave where you're submitting all of your invoices with an erroneous fee or profit margin baked in that wasn't agreed to with the government, every single invoice that you submit, which includes that erroneous fee or margin, could be tripled. In addition, every invoice would be subject to the penalty. And then in the example that Jackie gave earlier with implied certifications and fraudulent inducement, let's say you bid on a HubZone set-aside contract worth $7 million in revenue, and you're not in compliance with the HubZone requirements for whatever reason, and you know it, or you have reason to know about it. The entire value of that HubZone contract is subject to liability, which means that they would be tripling the entire value of that contract. And every invoice you submitted to the government for payment would theoretically be improper as well, leading to penalties for every single invoice. Now, we're giving you general blanket statements. There are defenses that you have to some of these arguments that we're making. But at the end of the day, that's the government's position, that you're going to owe treble the amount of damages that the government allegedly incurred. A little note on those penalties, the $12,500 to $25,000 per instance, that is adjusted by the government, usually on an annual, but sometimes more frequent basis, to account for cost of living and inflation rates. So only a couple years ago, those numbers were 11 and 22,000 respectively. Now they've already gone up to 12.5 and 25. So those numbers are the numbers apply to violations made during certain periods of time. For instance, let's say you had a violation that occurred in end of 2022, so December 1st, 2022. It's going to be subject to the penalty numbers on the screen here, but a violation earlier would be subject to the penalty at the time. These numbers are going to continue to go up for the foreseeable future. They are not adjusted down, and so they do have some pretty strong teeth when penalties are can impact the damages award. Jackie also mentioned this a little bit earlier. These False Claims Act cases can have a really long shelf life, and we're going to give you an example of that a little later on as well. The statute of limitations for an FCA claim is generally 6 years from the time the fraud was committed. What that means is if someone was to file, say, a qui tam lawsuit against you today, your claims could go all the way back to November 8th, 2016. That's a really long period of time to maintain your records, to maintain your knowledge about those records, and to ensure compliance. Not only that, though, the statute of limitations can be extended to 3 years from the time that the government official charged with investigating the fraud knew or should have known about the fraud. Now, there's a lot of case law out there interpreting this provision in a couple of different ways, but generally speaking, the prevailing rule is that once the Department of Justice, which is the agency that files lawsuits on behalf of the government for False Claims Act violations, once the Department of Justice knows about the claim, that 3-year clock starts to tick. So what happens if that government doesn't find out about the alleged fraud until year number 7? Well, that's okay, because all the way at the end of the slide, it goes never longer than 10 years. That means if the alleged fraud was well hidden, then the government could have up to 10 years of claims to go back. So we're talking about going all the way back to 2012 for a potential claim. So now I think it's important to talk a little bit about some recent FCA enforcement trends. Earlier this year, I attended a conference and a number of Department of Justice Civil Fraud Department attorneys were there speaking. And we've sort of boiled down not only what we've seen, but what they said at that conference into a few key bullet points here. So in fiscal 2021, and so early in 2022, there was a significant rise in government initiated matters, particularly compared to pre-fiscal year 2020. And there was somewhat of a decrease in qui tam initiated matters. What that means is that the government was relying more on its own audits and investigations than it was whistleblowers. Now, there's still a lot of whistleblower claims, don't get me wrong, but the government historically relied significantly on whistleblowers to do the legwork on the front end of an investigation, and it would pick up the investigation after a qui tam suit had been filed. We've seen a significant increase over the last few years in matters initiated by the government. So like we talked about earlier, through an auditor investigation or through an Office of Inspector General or DOJ having independent knowledge of some alleged wrongdoing. We expect those government initiated matters to continue to increase for fiscal year 2023, so the fiscal year that just started. But we expect that the qui tam actions are unlikely to continue their downward trend. One of the most important ways that a whistleblower can involve themselves in these investigations is to report to the government COVID and CARES Act fraud. So claims related to the EIDL loan program or the PPP loan program. Although some of those claims are things that the government could find pretty quickly, it's a lot more likely that the call is going to come from inside the house, so to speak. A CFO or an employee in accounts receivable knows that the application for the PPP loan or the EIDL loan itself was improper, and they're the cases that we're going to see a lot of over the next few years. So our recommendations from that is that we need to, or you need to take subpoenas, civil investigative demands, informal requests for information, or any other inquiries from the government made, say, in response to your annual renewal application for your 8A program status. If they are sending an informal inquiry about some bit of information on your 8A forms, you want to take those requests for information very seriously. And particularly if you're receiving a communication from an Office of Inspector General representative or Department of Justice representative. To ensure that you're avoiding FCA liability, you also want to increase your compliance efforts and your internal audit procedures. I recommend, and Jackie and I have talked about this periodically, that you assign a specific person or specific group of people who are responsible for an ongoing compliance with whatever set-aside status you are entitled to, whether it be small business or one of the set-aside programs. Someone needs to be assigned to understand those regulations and to be in charge of ensuring that the company is making its best effort to comply. Obviously, you can get attorneys involved for that as well. And very importantly, who are whistleblowers? As we talked about earlier, they are your employees or former employees. And so when employees are making complaints or providing notices or reports of alleged wrongdoing, sometimes it's easy to say, look, I know that's not really going on. You're alleging that our cybersecurity requirements are totally non-compliant and that the Russians are hacking us on a daily basis. The claim may be far-fetched, but the people who feel like they are not being heard when they make reports that are intended for the company's benefit are the most likely people to become relators under a False Claims Act claim. So take those complaints seriously, investigate them, keep records of your investigation, and make sure you're crossing your T's and dotting your I's to ensure that those complaints are taken seriously. So one of the major areas historically, currently, and inevitably in the future, one of the major issues for FCA is the healthcare industry. And a lot of that is driven by Medicare and Medicaid fraud. DOJ remains focused on using the FCA to combat healthcare related fraud. They're going to continue to do so in the future. That is inevitable. Where we are starting to see a little more enforcement on the healthcare side is to combat fraudulent telehealth waivers. There are healthcare companies that received PPP loans, Medicare Advantage program, FCA violations, and unnecessary medical services that are provided. The reason I skipped over kickbacks is because over the last 6 months, I have seen a significant increase in the number of investigations, settlements, and litigation initiated based on the anti-kickback statute. So what are we talking about there? When there's a semi-famous case from the 11th Circuit, which handles cases coming out of Florida, Georgia, and Alabama, where an individual reported to the Center for Medicare and Medicaid Services that certain types of private medical facilities that were receiving Medicare funds were providing essentially kickbacks to doctors to show up for speaking engagements or talks about certain types of plastic surgery and other elective procedures. And by doing so, by inviting these doctors on, the facility was giving benefits to potential patients to like discounts in order to, and free amenities in order to use these specific doctors with whom they had a relationship. Now, I'm not going to comment on whether that's an actual violation of the anti-kickback statute. I think there are a lot of cases that are currently going through the court system that will address that. But this is one of the most important and focuses of the government currently is that anti-kickback statute and how that is going to affect Medicare fraud claims moving forward. Another issue, particularly relevant to the healthcare industry, is fraud related to the COVID programs. These cases are often brought not only under the False Claims Act, but under a federal statute called FCA. And FCA is a statute originally designed for federal banking institutions. But it is being used by the Department of Justice to automatically extend the statute of limitations on False Claims Act claims to 10 years. And FCA has an additional penalty provision for anywhere from $1 to $5 million in penalties per violation. If there's one violation, the penalty is generally capped at $1 million. But if there are multiple, then the penalty is capped at $5 million, depending on the circumstances. These are all really important things to think about if you're in the healthcare industry. What are you representing to the government? What are you providing services for? What are you billing for? So anytime you're in the healthcare industry, the FCA is going to be a primary consideration for you. A little more about COVID-related fraud. At this conference earlier in the year, essentially the Department of Justice was asking for help. The Department of Justice does not have enough resources dedicated to CARES Act fraud to handle all of the possible fraudulent activities, excuse me, that have occurred over the last 2.5 years. So what they're asking for is the public's help. They are asking for whistleblowers to come forward, for lawyers to find whistleblowers to come forward and identify companies that received funds through the CARES Act improperly. Since the start of the pandemic, as soon as PPP loans and EIDL loans and other grant programs were initiated, DOJ has worked very closely with agency inspector generals in order to identify, monitor, and investigate the misuse of those funds. There are a number of settlements over the last 1.5 years where companies were dinged for receiving improper PPP loans, companies that weren't eligible from the beginning because of an automatic disqualifier such as a pending bankruptcy. DOJ has made it clear that it intends to continue to focus on CARES Act fraud. They have appointed an entire task force of individuals to help monitor and audit PPP loan materials to ensure that the companies are receiving proper funds, to determine whether there were false certifications and applications, either original applications or forgiveness applications. And cases against eligible borrowers have increased each month since about December of 2020. Obviously, I mentioned earlier, DOJ is asking for help. Qui-Tam plaintiffs are expected to heavily scrutinize how grant and CARES Act funds are being spent as well. Again, the call is coming from inside the house. If you're a CEO who is not paying attention to how your CFO is spending money, or your accounts receivable department is spending money that may have been received from the government as part of a CARES Act loan, you could find yourself or the company liable for improper payments under the PPP program. So a couple of recommendations from us related to CARES Act funds. Implement your own compliance programs to ensure that the federal dollars are spent for the reasons they were distributed in the first place. Understand the parameters of the PPP loan program and how those funds were supposed to be spent. And if you are seeking forgiveness, ensure that the funds that you did use were used for proper purposes. Also, critical in frankly any FCA context, but particularly with COVID-related fraud, you want to make sure that not only do you maintain your records, but you maintain detailed records to show how you complied with the PPP loan requirements, and to the extent you can, to show that you segregated the funds and to ensure that they were used for proper purposes.
So now moving on to some recent enforcement trends with the procurement fraud. DOJ has an ongoing focus on procurement fraud. They've announced a number of significant settlements related to alleged procurement fraud this year, showing that its focus in this area remains strong. These settlements are significantly lower than the number and value of settlements in the healthcare industry because that is just such a major focus under the False Claims Act. But the government still commits significant resources to investigating fraud in government procurement. And sometimes they do go after, I mean, not sometimes, often they will go after lower value contracts or allegations or potential damages. So, you know, even if your violation wouldn't result in a blockbuster recovery, it doesn't mean that you wouldn't be investigated for it. So, you know, there's many different types of procurement fraud that could lead to liability under the False Claims Act. So very important, again, to, you know, have a strong compliance program and, you know, make sure that you're paying attention to the representations that you're making to the government. So I want to walk through some of the different types of fraudulent conduct that we've seen settlements for, that DOJ has announced settlements for this year, so that you can have an idea of, you know, what are some of the specific types of conduct that has led to some of the, you know, different types of settlements. So, for instance, we've seen some settlements based on allegations that the contractor failed to comply with contract specifications. So as an example of this, in May of this year, a manufacturing company agreed to pay $3 million to resolve allegations brought under a qui tam lawsuit that it violated the False Claims Act by knowingly selling fabrics to the military that failed to meet required specifications. The company had allegedly falsified test results and falsely certified that its military-grade fabrics met all of the performance specifications on 100 separate occasions. So there's the representation that the product that's being supplied meets those specifications when that's not actually the case. There's also been settlements that are based on allegations of a contractor's noncompliance with statutory or regulatory requirements, as opposed to specifications for the product or service that's being provided. For instance, just this September, a contractor and its owner agreed to pay $625,000 to resolve allegations that the company violated the FCA by failing to comply with the Buy American Act requirements when they were selling scientific instruments to the government. And here, the government alleged that the contractor falsely certified that the goods that it sold, which were subject to domestic preference requirements, were of domestic origin when they were actually manufactured in China. You know, we're seeing increased requirements related to domestic sourcing requirements. Those thresholds for percentage of materials or components coming manufactured in the US are rising. There have been significant changes to the BAA requirements. So it's, you know, possible that we could see more FCA settlements or liability resulting from non-compliance with those changes to those regulatory requirements. And these types of cases that relate.
Real quick, Jackie.
Sorry, Matt.
Sorry to interrupt. I just wanted to make one comment. A lot of times you'll see these non-compliance with specifications or statutory non-compliance claims sort of framed in the context of a products liability case. So one of the famous cases recently is a case about ear protection for military members and how the company was supplying faulty ear protection. Ultimately, that case was investigated under both the False Claims Act and product liability matters, and there's a very large, one of the largest class actions in history being pursued over damages that individuals suffered as a result of not wearing or wearing ear protection that did not comply or was not adequately protective in a combat zone. And so there are a lot of, the reason I'm mentioning this is because the False Claims Act isn't always about money that is paid by the government. Sometimes it's about providing a substandard or subpar service to the government, or products to people representing the government at home and abroad. And so when you're thinking about the False Claims Act, you want to think about it in the most expansive way possible. how is the False Claims Act going to impact the business I do with the government, and making sure you're not cutting corners, and ensuring that you are compliant in all respects with the obligations of your contracts and the businesses or business ventures you're engaging in with the government.
Thanks, Matt. That's a really good point. Yeah, and we see courts being extremely strict with their requirement that contractors need to comply with all requirements of that contract and not cut those corners. One other thing that I wanted to mention with respect to the statutory or regulatory non-compliance is that those cases can be really tricky for contractors because those requirements often are so complex that it can be extremely difficult and burdensome for contractors to even understand what their obligations are. Specifically, like with that example that I gave with the Buy American Act, those just are very complex regulations that now are changing. And it can be hard for contractors who are trying to just run their actual business operations to stay on top of the numerous regulatory requirements that they're subject to. So that's why it's important that the False Claims Act requires not just the falsity of a claim, like where there is a non-compliance or misrepresentation about compliance, but that it be done with at least reckless disregard as to the truth or falsity of the representations, and that it require that the non-compliance be material to the government. And sometimes there are regulatory requirements that are not as important to the government, and they're willing to overlook it. So those requirements of knowledge and materiality help protect contractors that are operating in good faith, but fail to meet those requirements in all instances, as long as they are not ignoring red flags that are apparent about their non-compliance. So the next category I want to touch on is improper billing and kickbacks. As an example here, in March of this year, a construction contractor agreed to pay $10 million to resolve allegations that it overbilled the government by presenting false invoices for non-existent materials submitted by a subcontractor to the contractor, where the contractor was supposed to confirm receipt and acceptance of the materials from the subcontractor prior to submitting claims to the government for those materials. But it basically just ignored its obligation to review, and ensure that those materials were received before it just passed on all of the claims from the subcontractor to the government for payment. And the government also alleged that the contractor's employees received kickbacks from the subcontractor to induce them to submit those claims. DOJ has also announced a number of settlements of allegations related to small business fraud. So some of these allegations relate to misrepresentation of a company's small business size or socioeconomic status in order to receive contracts in the first place. This kind of gets back to what Matt was talking about earlier about the concept of affiliation. So a small business may not actually be small if the business has affiliates as defined under SBA's regulations, and it fails to account for its affiliates' revenues in calculating its size. Or if down the road, initially a business may start out as small, but it may lose its small business status after a merger and acquisition. Certainly it depends on the specific circumstances and the timing of the relationships of that company. Also, outside of affiliation, a company may misrepresent its socioeconomic status where it's not actually owned and controlled by the proper individual. For instance, a woman for a woman-owned small business, or a service-disabled veteran for a service-disabled veteran-owned small business. So as an example of this, in June of this year, DOJ announced a $5.2 million settlement with a manufacturing company and two related entities to resolve allegations that the company violated the FCA by improperly obtaining 22 small business set-aside contracts that it was ineligible to receive after its acquisition by and resulting affiliation with a larger company. And then DOJ also alleged that the company falsely certified that it was a woman-owned small business concern. So, see a number of settlements in that area. We've also seen settlements for allegations that relate to contract performance rather than initial eligibility. such as the failure to comply with the requirement that the small business prime contractor perform a certain percentage of the work itself under the limitations on subcontracting. For instance, generally the small business prime contractor needs to perform at least 50% of services, the work under a services contract, or 15% for a construction contract, versus subcontracting out the work to entities that are not similarly situated to the prime contractor. So, in this situation, DOJ is really concerned with the small business essentially acting as a sham or a pass-through entity, where a large or an otherwise ineligible business ends up doing the majority of the work and getting the associated payment instead of the small business who is, intended to perform and receive those funds. One notable settlement in this regard is from February of this year, when DOJ announced that a kitchen and food service equipment company agreed to pay $48.5 million to resolve allegations of small business contracting fraud, which is the largest ever FCA recovery based on small business contracting fraud, to date at least. And as part of the settlement, the contractor admitted that its conduct caused the government to award small business and SDVOSB set-aside contracts to eligible firms, but then the contractor, rather than the eligible small business, actually performed substantially all of the work under those contracts. The small business was really just serving as the face of the contract. The contractor also admitted that it identified set-aside opportunities for the small business to bid on. It instructed them how to prepare their quotes and what its pricing should be. It actually ghost wrote emails for the small business to send to the government to make it look as though the small business was performing the work, and it concealed its own involvement in the contract. So, that's pretty egregious conduct there, which results in this large settlement for this one. And then I also just want to point out that there can be liability for prime contractors who are obligated in their contracts to use good faith efforts to subcontract to small businesses through their small business subcontracting plans, and where they misrepresent their efforts to do so. So it's not always the small business contractor, it can be the large business prime contractor as well. So for instance, here as an example, in May, a large construction company agreed to pay $2.8 million to settle allegations that the company improperly manipulated a subcontract reserved for SDVOSBs. The government awarded the company a contract to develop retirement communities and residential facilities for veterans. And a condition of that contract was that the prime contractor needed to provide subcontracting opportunities to SDVOSBs. In the settlement agreement, the company admitted that it negotiated with a non-eligible company for the subcontract, but then after it had concluded those negotiations and figured out all the terms, it entered into a subcontract with an SDVOSB for the same work, but with an additional basically pass-through 1.5% fee for the SDVOSB. And then, where at the end of the day, the SDVOSB was a pass-through, and it was this initial large business non-SDVOSB which performed all of the work under the subcontract. So, we're definitely seeing an uptick in enforcement with respect to small business programs and fraud under those small business programs.
And before we go to the next slide, just because a company is a small business, this doesn't limit it just to, say, sole source awards or competitive small business awards. It also involves when you're bidding as a joint venture or as a CTA, contractor teaming agreement arrangement. All of these rules implicate the False Claims Act across relevant contracts. And so not only do you need to understand, at least as a threshold level, your limitations on subcontracting and performance of work requirements, you also have to understand them clearly and for your joint ventures that are performing work too.
Thanks, Matt. So now we want to go on to talk about a few things that also happened in fiscal year 2022. We're going to talk about the first civil cyber fraud initiative settlement, an update on the procurement collusion strike force, and this recent case, Skullick versus Narula, which is a long-awaited decision that's recently come out. So first, let's talk a little bit about the civil cyber fraud initiative. In October of 2021, DOJ announced this new civil fraud cyber initiative to combine the department's expertise in civil fraud enforcement, government procurement, and cybersecurity to combat new and emerging cyber threats to the security of sensitive information and critical systems. The purpose of the initiative is to pursue contractors' misrepresentations in connection with the government's acquisition of IT software, cloud-based storage, and related services designed to protect highly sensitive government information from cybersecurity threats and promises. The intent with the initiative is not to create new cybersecurity requirements, but to better enforce those requirements that already exist and to deter non-compliance with those existing requirements. So liability under the FCA as a result of the efforts of this initiative wouldn't necessarily stem from a cyber breach in the first place, but rather when the company misrepresents its compliance of its security program or its reporting, because again, FCA is based on representations or failures to disclose non-compliance to the government. And DOJ has used the FCA to pursue alleged non-compliance with cybersecurity regulations in the past, but this new initiative really underscores there will be more of a concerted effort to prioritize this type of fraud moving forward. So as an example of that, we've got our first civil cyber fraud initiative settlement. If you can, Matt, can you move to the next slide?
Yep.
Okay. So in March of this year, DOJ announced its first settlement under the initiative with a medical services contractor who agreed to pay $930,000 to resolve allegations that it violated the FCA by falsely representing to the government that it complied with cybersecurity contract requirements. The healthcare industry is consistently the recipient of FCA oversight, so it's no surprise to us that this first settlement was with a healthcare provider. The alleged misconduct, though, it's important to note, was not simply that there were flaws with the company's cybersecurity system, but rather focused on the contractor's request for payment despite its alleged failure to disclose that it had not consistently stored patients' medical records on a secure electronic medical record system as was required by the contract. So again, as I just noted on the last slide, it's not necessarily about that breach in the first place or that non-compliance in the first place, but the representation related to it through the request for payment, generally representing that the contractor was in compliance with those privacy requirements through the secure electronic medical record system that they were supposed to have. And one notable point about this, in its press release of the settlement, DOJ noted that even after staff raised concerns about the privacy of protected medical information, the company still didn't take adequate steps to store the information in a secure manner. So that again goes to the point that we've been discussing about the knowledge requirement under the FCA that there needs to be at least reckless disregard by the contractor, and that can be shown when there are red flags, when there are concerns or complaints that are raised by employees or others about being non-compliant with requirements, but failing to take any action in response to those situations. One other notable settlement related to cyber fraud is the settlement of the Aerojet Rocketdyne case, which DOJ announced in July. So this was a key TAM lawsuit that was filed against Aerojet back in 2015, which alleged that Aerojet misrepresented its compliance with cybersecurity requirements and contracts with DoD, NASA, and other federal agencies. In May of 2019, the judge denied Aerojet's motion to dismiss the case, holding that Aerojet's compliance with the cybersecurity requirements could be deemed material to the government's decision to award Aerojet the contracts and pay its invoices. And then the trial was set to move forward this summer, but on earlier this year. And on the second day of trial, the parties finally agreed to settle the allegations for $9 million payment from Aerojet. This relates back to what Matt was talking about much earlier in our presentation about the long shelf life that FCA investigations and litigation can have, because it really can go on for years past when the conduct occurred for the investigation by the government and then the litigation. Each of those processes can take a number of years to play out. And then finally, it took until trial had actually begun for the resolution to occur through this settlement. So these cases illustrate the broad approach that DOJ is taking to use the FCA to combat perceived cyber threats. And this is another area that we're anticipating additional enforcement in the future. Next, I wanted to touch on DOJ's procurement collusion strike force, which kind of has a bit of overlap with FCA, or is at least tangential to it, and critical for contractors to be aware of with respect to their procurement activities. So a little background, in November of 2019, DOJ announced the formation of this interagency procurement collusion strike force, which is made up of prosecutors from DOJ's antitrust division and 13 US attorneys' offices and investigators from FBI, DOD, OIG, and other OIGs. Its purpose is to deter, detect, investigate, and prosecute antitrust crimes which undermine competition. So initially, when it was first formed, the strike force's priority was conducting outreach and training for both federal government and industry groups to kind of teach them about what kinds of anti-competitive behaviors were illegal and how to identify and investigate those behaviors. But we've seen now a shift in the focus to enforcement and the focus on opening investigations and pursuing convictions, which really doesn't seem to show any sign of slowing down. To the contrary, it's probably going to continue picking up. DOJ recently reported that since the strike force's inception, it's opened over 60 investigations and prosecuted over 30 companies and individuals involving over $350 million worth of government contracts. The strike force has obtained a number of convictions just this year on bid rigging and bribery charges, for instance, where companies conspire to submit intentionally high bids with an agreement as to which company will submit the low winning bid. Or another example of the legal conduct is where defendants create sham bids in return for bribes or unlawful payments. Another point about the strike force is that the original mandate is really related to criminal activity, criminal per se antitrust violations. But we've seen the strike force pursuing general fraud and collusion cases even when there's no clear traditional antitrust cause of action. So it's just very important for contractors to review their procurement practices to make sure that there's no collusion with competitors or teaming partners, and to make sure that they have an effective compliance program in place so they can seek leniency if they find themselves under investigation. I'm going to turn it over to Matt now to talk about this important recent case that has come out.
Right. So this summer, a very long-way decision was reached in Skolik versus Narula. And as a quick disclaimer, I was previously involved in the Skolik versus Narula case. I am no longer, and so I feel capable of commenting on it. So this is a 2014 case that was filed by a whistleblower in the U.S. District Court in the District of Columbia. And so again, here's that long shelf life. We're 8 years later and the case is still going on. It's based on alleged service-disabled veteran-owned small business fraud through the VA. So essentially what was alleged is that a group of individuals got together and created a company and placed a service-disabled veteran at the helm who wasn't actually in charge of the company, and these other non-small businesses were essentially running things. The reason that this is an important case is because over the last 5 years, there's been a particular focus on whether there can be liability for a surety or an insurance company that is bonding out or insuring losses related to federal government contractors. And this touches quite a bit on sort of that conspiracy to commit the False Claims Act violation and Reverse False Claims Act type violation. And the plaintiff in this case proceeded under two theories. The first was that the construction surety's actions facilitated or contributed to the presentment of a false claim to the government because the surety itself was bonding out the construction project, and the construction project could not have proceeded without a bond. And so this is a very broad allegation where the whistleblower was attempting to bring the surety in a deeper pocket in order to impose a specific duty on the surety to do an investigation to ensure that the companies it was bonding out were in compliance with their contract obligations. And the second theory was that ultimately a surety or an insurance company has an obligation to pay the government under a bond if the underlying federal contract was breached. So if the surety knowingly fails to pay the government on the bond when there has been a breach, it is theoretically a reverse False Claims Act violation. In this case, the court rejected those arguments, at least under the facts in Skolnick, because it would require the surety to be familiar with the SCBOSB program requirements, and the court refused to impose an affirmative duty on insurance and bonding companies to double check the government's verification of a party's set-aside status. Now, there's a couple of things to keep in mind. I don't think that this case is going to make False Claims Act claims in the construction industry harder to prove or prevent relators from suing sureties. But what it does give us is a little bit of guidance about how things are going to move forward in the future. The SCBOSB program through the VA does have some certification requirements, and the government is involved in determining whether a company is an SCBOSB. But that is not the case with other agencies. In many respects, the SCBOSB is a self-certification program. And perhaps in another case, the government not double checking on a status, an SCBOSB status for a contractor, a surety may have an obligation to look into that to ensure that they're not violating the contract. And so I would expect over the next few years for relators, whistleblowers, and plaintiffs' attorneys to develop different arguments and new innovative theories about how to expand the scope of qui tam litigation in the construction industry, including trying to bring in sureties and insurance companies as may be necessary. But this case got a lot of attention, essentially since it was over the last 4 years. And so this was likely to be a bellwether case, something that shows other False Claims Act courts how to respond to claims that a third party is somehow required to ensure compliance with a single contractor's performance.
So this slide is kind of reiterating some of the points that we've already touched on, so I'll go through it quickly, but just some trends going into FY 2023. We believe there will be primary focus on the healthcare industry, particularly with regard to COVID-related fraud, such as PPP loans and telehealth waivers, as well as CARES Act fraud, which Matt spoke to earlier, and also increasing DOJ focus on the small business size and status certifications, as well as set-aside eligibility, mentor protege program, and joint ventures, with respect to DOJ's concerns about pass-through or sham small businesses that solely serve as a front for their large business partners to actually do the work. And also increased focus on procurement fraud and illegal anti-competitive conduct, which we spoke to earlier. Especially expect that to be the case with increased spending through the bipartisan infrastructure law and the Inflation Reduction Act, which both have quite a bit of spending coming out of them. When we see all of those funds goes out, there's the potential for increased fraud. And then the enforcement, the investigation into that and the enforcement of that takes, as we've talked about a number of times, has a long shelf life. And so there's a many-year period where the conduct related to that spending can be investigated. So we expect to see this focus for a number of years still.
Okay. So what happens when you're doing business with the federal government, you start to get worried about FCA issues? How are you going to protect yourself from FCA liability? We've touched on this a little bit earlier in the presentation, but we're going to sort of hammer it home here. You want to ensure regulatory and contract compliance. And what we mean by that is you need to know what your contracts require and what the law requires of you. If you are a woman-owned small business, you or someone at your firm should be very familiar with the woman-owned small business regulations, or you should develop relationships with attorneys or industry experts who know the women-owned small business regulations very closely. When we talk about contract compliance, you might have a contract that's 150 pages long. You need to be very familiar. You need to dedicate the time and resources to ensure that you are in compliance with all contract requirements. Whether that's cybersecurity or invoicing or any number of requirements that may not be so obvious in the contract. For instance, it's generally speaking, you might be required to provide 8 subject matter experts over the course of a contract. That's an easy one. You'll know that that's required. It was part of your proposal. But there may be an aspect of the contract that isn't so obvious. It's important to read your contracts, highlight the places where work is required or a deliverable is required or some submission is required in a certain form, and you ensure that you're in compliance with that requirement. You should have internal audit procedures. So you may perform a contract for 5 years. It's important to understand that the information you're submitting to the government is accurate, that the performance of work you are engaged in for a specific contract is done correctly and in accordance with the contract requirements. And it's not enough simply to look at the very beginning of performance and determine that, okay, we're going to do this correctly, or check at the very end right before contract closeout and make sure that you've been in compliance. What you really need to do is ensure that you are auditing as you go along and making sure that you're in compliance with your regulatory and contract requirements throughout performance. You should, or at least I could recommend, having standard operating procedures for the way that you handle invoicing to the government, for the way that you handle contract compliance. As I mentioned earlier, you're going to want to specifically assign certain duties to representative employees. That may be your contracts manager or a deputy contracts manager. That may be a specific project manager for a contract. Whoever the person most well equipped to handle the contract compliance requirements for a specific contract, that person should be assigned those duties. But it's best to have multiple people involved, or a checks and balances or oversight process to ensure that one person slipping up doesn't cost the company hundreds of thousands or millions of ultimate dollars in the end. And finally, have some internal checklists, particularly if you are required to follow regulatory requirements for a set-aside program. You want to make sure that you are checking the boxes, ensuring your continued compliance. For a PPP loan, you might want to make sure that you're paying the money out in ways that it was required to be allocated. Obviously, training is a huge part of this. You want to make sure you're training your employees, the people responsible for the company's reputation and submissions to the government, and you want to make sure that they understand their requirements and the requirements of your contracts, so that they are so that they can guide your employees. We mentioned this a little bit earlier. You want to take any employee complaints or comments very seriously. In, I want to say 2018, perhaps 2019, there was a $9 million settlement on cybersecurity FCA violations for Cisco. The allegations in that complaint were that a cybersecurity analyst for Cisco reported several times to supervisors that the company's programs were not in compliance with the government's obligations. Those complaints were ignored. That person eventually filed a key tam complaint, and it resulted in a $9 million settlement. So when you get those complaints, you want to investigate them very closely. Ensure you have a robust paper trail that shows the scope of your investigation. And if the allegations have no merit, you need to make sure that your paper trail justifies that they have no merit. If, on the other hand, the allegations do have merit, you want to document how you resolved that matter, and I'll get to this at the bottom of the slide, and who you told about getting that problem fixed. It also helps to have a contingency plan. What am I going to do when I see that an FCA violation has happened? When I finally notice that we had an incorrect formula in our invoice and we've been billing the government at 3% instead of 2.5%. who are you going to speak to, who are you going to hire to assist you, and how are you going to disclose that information to the government? So what do you do when you discover a past or current FCA violation? This is a really important issue because you have a mandatory disclosure requirement as a federal contractor. If you believe that someone in your company has violated the FCA, which has resulted in the government receiving a false claim, you have a mandatory disclosure requirement. You must disclose to the government and correct the mistake. This can help because at the end of the day, if it's a serious FCA violation, you can get cooperation credit from the Department of Justice and reduce the amount of damage that you may ultimately be liable for under the False Claims Act violation. There are a number of hoops you have to jump through, including turning over the person responsible for the violation and a number of other things, but mandatory disclosures are very important. And now what happens if you're faced with an FCA matter? Maybe you received a grand jury subpoena or a civil investigative demand, a civil subpoena or a search warrant. Perhaps the Department of Justice and the FBI have showed up on your office steps with a warrant. What are you going to do? That's when you implement your contingency plan. Now, a lot of you are going to say, do I need a contingency plan if I'm not violating the FCA? You should. You should have it because you never know what's going to happen. Key TAM relators do not always tell the truth. They also don't always have the total information necessary to make an actual claim. And so what they do is they fill in the blanks with what they've seen or what they've heard. It may not necessarily be taken in context. It may be wildly out of context, but that doesn't mean that that individual hasn't come to the belief that there is an FCA violation. So it's important to have that contingency plan because you don't know what they're telling to the Office of Inspector General, to a lawyer, or to the federal government. But don't panic. The world does not come to an end simply because the government has served a subpoena on you. That said, don't talk to the government and say and reach out and say, hey, I received this subpoena. I didn't do anything wrong. At that point, once you've received that subpoena, you need to retain counsel. A civil investigative demand is very similar to a subpoena. If you're getting a document from the government that says anything about the False Claims Act, you need to get an attorney involved so they can guide you and communicate with the government on your behalf. If on the unfortunate event you receive a search warrant, if the FBI shows up on your doorstep, always ask to see the search warrant. And as soon as you look at it, take a picture of it if you can, and get an attorney on the line right away. So when you get these investigative demands or subpoenas, you want to stop routine document and email destruction or archiving of documents. You are going to be producing documents to the government. You want to have them at your fingertips so that you can produce them quickly and efficiently. Again, you're going to want to obtain knowledgeable counsel to act on your behalf. The government's attorneys are attorneys. They're going to take advantage and take leeway where they can, and they are less likely to do so when there's an attorney involved. You want to conduct an internal investigation. Maybe you have no idea what this civil investigative demand or subpoena is about, but at the instruction of your counsel or with the involvement of your counsel, if you engage in an internal investigation to get to the bottom of things, you're going to identify the knowledgeable witnesses and the relevant documents that either prove or disprove your position. We've talked a lot about a paper trail. You want to verify your paper trail. Do you have it? Did you take it at the time? Make sure it's not destroyed. Understand where those documents are. There's nothing worse than looking for weeks to find documents that you know exist, but you haven't been able to locate them because they've been put in a box somewhere in a closet. And finally, we can't emphasize this enough, documentation, documentation, documentation. You want to document what you've done to compile the documents, where you looked, what you found, and your communications with your lawyer. And all of that can potentially be privileged if you've got knowledgeable and invested counsel on your behalf. So I'm sorry, we've gone a little bit over or a lot over 15 minutes. We didn't receive any direct questions to talk about during the webinar, but if you have any right now, please reach out to Jackie or to me directly. Our phone numbers and our email addresses are on the slide that's up on the screen right now. We very much appreciate your time. We give these FCA webinars usually at least once a quarter or sometimes more often. We hope to see you on a future FCA webinar. I'm going to boil all of it down again to sort of how I started it. Yes, there's going to be significant enforcement. The FCA is going to continue to be the government's primary vehicle to recover money. And with that, there's going to be enforcement. We hope that you've gotten some important information for your company today, and feel free to reach out to us if you have any other questions.